Hello and welcome to the Wire Talks. An independent judiciary is a crucial pillar of democracy, and India has long pointed to its judiciary, its courts, and also the media as exemplars of its robust democracy. But in recent years, the perception has grown that these institutions lean more towards the political establishment rather than towards protecting the rights of citizens. Our guest today, Chander Uday Singh, a senior advocate of the Supreme Court, has written and spoken about this extensively. Singh began practicing law in 1984 after he had worked in agriculture in Punjab for 4 years and also in journalism as a reporter for India Today in Mumbai. After graduating from the Government Law College in Mumbai, he worked in the labor courts and in the Bombay High Court and then shifted to the Supreme Court, where he has handled many public causes such as the Aadhaar case and the abrogation of Article 370. He's also worked extensively on commercial cases such as intellectual property and regulatory matters for the Securities and Exchange Board of India. Chander Uday Singh, welcome to the Wire Talks.
Thank you.
Chander, 3 years ago, you wrote an article with the headline. Now, obviously, you didn't give the headline, but it's based on what you said. As the Supreme Court turns 70, is the Sentinel sufficiently alert, or is it in danger of losing the plot? Quite a provocative headline, I must say. The courts are supposed to be sentinels of the human rights of citizens. Have they fulfilled that mandate?
The Supreme Court has created a huge level of expectation among the citizenry of India. We have a situation where our Supreme Court, and in fact the court system in general, has stood up over various periods of time, but especially if one took the period post-emergency from 1977, for the next about 20 or 25 years, the Supreme Court and the High Courts were truly exemplars of protecting the interests of the weakest citizens, trying to balance the interests of big business and governance and strong governments with protection to labor, with protection to trade unions, with protection to tribal rights, and so on. So there was a great level of expectation that was built up because the Supreme Court stood up and stood out, perhaps more than any other court in most parts of the world, except perhaps the Constitutional Court in South Africa and all, which came onto the scene much later. What has happened when I wrote this 70 years into the history of the Supreme Court was that there was a feeling that the Supreme Court and some of the High Courts also were slipping up on fulfilling those expectations, and that a trend had come when the courts were not standing up to big government and very powerful governments. There was a feeling that there's no pushback against arbitrary government actions, and that the Supreme Court was tending to become a court that spoke for the establishment rather than to protect the citizen. That was the background in which I wrote that, and after that, there has been, a continued feeling that issues that need to be grappled with have been put on the back burner, and that the Supreme Court has been failing in actually tackling the most important issues of the day. I don't want to make this sound like an absolute, because courts have a sort of they have their ups and downs. And right now we have a new Chief Justice in place, and every Chief Justice who comes in, we as lawyers, and I think the citizenry in general, has very high expectations, and the feeling again is that the new Chief Justice is taking the bull by the horns and is seeking to give primacy to issues that really matter. So, we really need to give the new Chief Justice a chance. And though his tenure is very short, there is going to be another Chief Justice following him who will have a longish tenure of about 2.5 years. So one's hopes are very high, one's wishes are very high, but we do come to it with a feeling of trepidation, because we've faced about 7 or 8 years of a downward slide, in my opinion.
Can you give some examples of this downward slide, to quote your phrase?
There's the two different ways in which this happens. One is delay and procrastination. That is, to just not list matters that need to be listed is one way of putting them where they go on the back burner, and the issues that need to be dealt with just don't come to the fore at all. So there are a large number of issues which have been filed, which are pending before the Supreme Court of India, for instance. Over the last several years, we have challenges, for instance, to the Unlawful Activities Prevention Act, where there were extensive amendments made in 2010 and 2019. There are challenges which are pending. There are challenges to love jihad laws, which are, weirdly named as freedom of religion laws, which are actually anything but promoting freedom of religion. There are challenges to the beef bans that were sort of strengthened and exacerbated in the post-2014 era in several states. There are challenges on a very major level. There are challenges, for instance, to the electoral bonds, which are widely perceived as being seen to terribly skew the freedom of parties to fight elections, because the way the electoral bonds are framed, they allow anonymous donations, and the bulk of those anonymous donations go to the party in power. So we have more recently, we have issues like the Pegasus disclosures. We have, the information technology rules, the intermediaries rules. We have challenges. There's a large number of challenges pending. And of course, there's the abrogation of Article 370, which took place as far back as in August 2019. These have actually come up before constitution benches. They've been heard for a while, and then they've gone on the back burner again. So one form of slide is procrastination, which could have the tendency, and sometimes does have the tendency, of rendering issues completely academic. For instance, demonetization was challenged immediately on its being promulgated, and today, even if those matters are heard, they will in all likelihood be completely academic. There are several important bills which have been pushed through as money bills, where on the face of it, it appears to be a fraud on the Constitution, because these are laws which are anything but money bills, and including, for instance, the Prevention of Money Laundering Act and the amendments made to that act, which have been upheld by one bench of the Supreme Court, even though they have one substantial challenge to those is that they were passed as money bills, and therefore they are void ab initio. So, but that particular challenge has been put on the back burner. The challenge to the NRC and Assam has been put on the back burner. Many of these issues become completely academic by the time they get heard. So that is one form of procrastination. The other thing where we talk about a slide is where decisions are given which are seen to be very strongly favoring the establishment. And there are several such examples. And for instance, constitutional scholar Sidharth Bhatia has at several times called the Supreme Court an executive court, that the Supreme Court is sliding into, from being a court for the people, it's become a court for the executive. And there are several such instances. So just to take one example, the challenges to the Central Vista, the entire redevelopment of Parliament and the Central Vista, there was a challenge in the Delhi High Court. The Delhi High Court issued certain interim directions. The petition was pending there. There was no other petition anywhere. The interim directions came to be challenged before the Supreme Court. Either the grant of interim directions or the refusal of interim directions, I'm a little fuzzy on that, was challenged before the Supreme Court. The bench before whom it came up said that while dealing with a pure and simple challenge to interim directions, they said we will pull that petition up to ourselves and we will ban all other petitions. We will not allow any court in the country to deal with any petition on this subject. So when they were faced with only very limited, narrow challenge to an interim order, which they could have either rejected or granted, they instead pulled up the petition. Then they took up the entire thing, and they, by a majority of 2:1, even though there were very important constitutional issues, there were very important jurisdictional issues, and the Supreme Court really had no business dealing with that subject at all, by a majority of 2:1, with the dissenting judge saying that this is completely violative of the Environment Protection Act, that the permissions which have been given are absolutely void, etc., etc. The Supreme Court nevertheless proceeded to, sort of give a complete whitewash or a clean chit to that entire scheme. So this is where one gets a perception that here is a court acting like an executive court. It is pulling matters up to itself. It's stopping other people from dealing with those matters. And then it is either sitting on those matters and letting them atrophy, or deciding them in a manner which is very, very clearly suited to the executive in power. We have many such instances, and I don't want to, clutter up this discussion with them unless you want anything specific on that. But this is the other form where the Supreme Court is seen then as a court which is slipping up on its earlier reputation, on its wanted reputation and well-earned reputation for being the court for the people and of the people.
So, Chander, what you've said shows that delay and procrastination makes the whole thing redundant. And Central Vista, for example, has come up because even if there is a judgment which raises questions about the Central Vista, it's done and dusted. But what about the rights of the citizen for, let's say, arbitrary imprisonment? What about bail? What about hearing the citizens' petition to say, I was illegally arrested, or this case is made up, or whatever? In 2020, Justice Chandrachud had said, basic rule of the criminal justice system is bail, not jail. And yet, while the courts act with alacrity in some cases, I won't say which ones, because that's also a matter of a citizen's right, Omar Khaled is still in jail for 2 years, even though he never invoked any violence. And many other human rights defenders are also in jail.
Yes. So this is the other side of the coin. You're absolutely right to, focus on human rights issues. One of the where these two issues dovetail into each other. One is that the challenges to the kind of amendments which have been made to the UAPA, for instance, the Unlawful Activities Prevention Act, which have made it almost impossible to get bail under that, or the amendment which was made to the Prevention of Money Laundering Act. These challenges are pending. Some challenges have been dealt with by the Supreme Court. Some are kept pending. The issue of money bills, for instance, now because those issues are not being grappled with, these draconian provisions continue in force, and then acting under the draconian provisions, the citizens, and particularly those who are seen as social activists, human rights defenders, university students, and so on, are picked up and are incarcerated for long periods of time in two ways. One is that the laws under which they are charged, which appear very clearly to be not applicable, but are so draconian that by the time you can prove that you are that you have not committed any offense under that particular law, you've already spent a year or 2 or 3 behind bars, which is happening, for instance, in the Bhima Koregaon 16, out of which one person has died very tragically, Father Stan Swami, and so on. Now, where the Supreme Court could have sent a message and has failed to send a message is that when subjects like this come up, the Supreme Court ought to jump in with both feet and say that we are going to look at this issue. We are going to examine how this is being misused, because the misuse is writ large on the face of it. You have to be both blind and deaf to not realize, to not acknowledge that these laws are being misused right across the board. Now, for instance, in Siddiqui Kappan's case, habeas corpus was first moved before the Supreme Court. The Supreme Court kept it pending for 6 months. And after 6 months, they said, and because that habeas corpus was pending in the Supreme Court, he could not apply for regular bail. Now, for whatever reasons, he was advised, or his family was advised to file the habeas corpus, which was filed by the Kerala Union of Journalists. But it was kept pending for 6 months, which is tragic. And at the end of 6 months, the Supreme Court said, no, you go back to the Allahabad High Court, why have you come here under Article 32? And so then they went and applied for regular bail, and that took another year. And finally, when he was finally granted bail by the Supreme Court very recently, a few days ago, he's still not free because there's another case under the Prevention of Money Laundering Act foisted on him. This is the same sort of thing which is done again and again. It was done with Mohammed Zubair, that one case after another. And the Supreme Court in that case rose to the challenge and said you can't keep foisting multiple cases on a person for the same nature of allegations. It is the same sort of thing which is being done with Siddiqui Kappan, the same sort of thing which is done with various others. Now, Umar Khalid, for instance, is a case where he is being roped into a conspiracy for fomenting violence and riots. And the speech that he gives calls for peace and complete non-violence. And the entire charge sheet proceeds on the basis that when you call for peace, it's a coded message to indulge in violence. I mean, it's most bizarre, situation which it's nothing short of Kafka-esque. This is Franz Kafka, where black is white and white is black, and you can just foist any charges on anybody. But where the Supreme Court should weigh in and should have weighed in is by taking up these matters and deciding them expeditiously. Now, we tend to forget that we have one very large province in India, and whether that province is entitled to autonomy or it's not entitled to autonomy, it is a province of India which is known as Kashmir, Jammu and Kashmir. Now, before the abrogation of 370 and after the abrogation of 370, the Public Security Act has been used, Public Safety Act or whatever has been used over there mercilessly to incarcerate everybody and anybody for 1 year without it's just a pure preventive detention with no reasons at all. Now, when 370 was being abrogated, before that, several people, including people like the president of the Jammu and Kashmir, the High Court Bar Association, were picked up and they were all shipped out of Jammu and Kashmir and put into jails in Agra and Meerut and Bareilly and here and there and everywhere. They stayed behind bars for that full year. And the Supreme Court, for instance, granted bail to the president of the Jammu and Kashmir Bar Association at the end of a year in a case where the Public Safety Act itself allows detention only for a year. So what is the message which is sent out? That if you happen to be aligned with the powers that be, your case will be fast-tracked and will be decided in 1.5 days or 1 day. And if you happen to be from a province in the north of India known as Jammu and Kashmir, your case will not be heard. People are even today languishing behind bars all the time. They're released on bail, and the moment they're released on bail, they're picked up under the PSA and put back behind bars. Now, this is a strong message has to be sent out, and the message can only go out if the Supreme Court takes up 1, 2, 3, 4 cases and passes strong orders in those. And there's no doubt that those orders have to be passed, because whenever they do deal with it, they invariably grant bail. But what is the point of granting bail 6 months, 1 year, 2 years, 1.5 years after the event? So we have a court which is failing the citizens, like I said. They may say the right things, but if you say the right things 1.5 or 2 years down the line, then the damage is already done. There is a huge chilling effect on journalists. There's a huge chilling effect on social activists. We have a relentless assault on charities and all kinds of NGOs and so on. But the courts take their time. They take their time and they hear these matters in the most leisurely fashion, which encourages the government to then continue with this assault on all kinds of social activists, including those who are completely innocuous.
What you're saying basically is that the kind of assault is coming at different levels, and the word impunity is used a lot, but the government feels confident that it can get away with it. Either there'll be a terrible delay, by which time it will become, as you said, moot, or there will be, it will go towards, it will lean towards the government and away from the citizen, because clearly if the Supreme Court wanted, Umar Khalid, the second case, could have said, we have passed the orders, you have to release him. So that gives the government a certain sense of confidence that it can get away with whatever it's doing.
Well, I certainly, in a case like that, I think it's great that we have a new Chief Justice in place. He has fast tracked these matters. So I don't want it to appear that we as members of the bar are not cognizant of the fact that there's a strong effort being made to push back against the excesses of the state, and we are really hopeful that the Supreme Court will rise to the occasion. The only thing is that, for instance, to take Umar Khalid's case, when the Supreme Court granted him bail, they were told that there's another case, right? And they could have added a small rider saying that if there's any other case, it shall be heard and decided within 1 week, right? If they had, without opining anything on the case, they could have said decided within a week or decided within 2 weeks, right? So once that decision came, there would have to be another decision by whichever court is where he's held up, because now he might face another interminable delay in the next matter. And it's no point, telling him that spend another 5 months, 4 months, 3 months behind bars so that the next case can be heard and decided, because they could foist a third case on him.
Yes, as you rightly said, this reminds us of Munawar Farooqi. We'll be right back after this short break. Welcome back to the Wire Talks. The new Chief Justice, whom you have mentioned 2 or 3 times in this discussion, has given Teesta Sittlewad bail. He said in some other case that protesting against the government is not a crime. So he's here for only 3 months or less than now. So do you think somebody like him could set the tone?
I think Justice Uday Lalit has already, injected injected some vim and vigor into the spine of the institution, to use a very mixed metaphor. But the very fact that a Chief Justice from his pulpit can, not just talk the talk, but walk the talk, it makes a huge difference. It makes a huge difference because many judges, ready and willing to go that extra mile and to discharge their duties towards the citizens. I would always feel that the vast majority of judges are ready, willing, and raring to go. But Chief Justices, by the way matters get assigned, by the way matters get listed or not get listed, they can deny that majority of judges the opportunity to grapple with the issues of the day. When a new Chief Justice, when Justice Lalit has taken over and he has listed a large number of matters, he has ensured already that a whole bunch of matters have got listed. And the promise is, the implicit promise which is hanging in the air, is that some of the political hot potatoes also are likely to get listed in the very near future. Now, if matters like electoral bonds get listed, see, a decision can come either way, because ultimately it's going to be a judicial decision. It could go one way or the other, and we would live with whatever decision comes on it. But to sort of allow a matter to die a slow death, to allow an issue to become infructuous, that is something which is really, really hurting the system. And the very fact that the new Chief Justice has clearly declared his intent to pull these matters out of cold storage and to list them, we hope that several of them will get listed during his short tenure, and we hope that the incoming Chief Justice will continue on those lines and will ensure that all these issues get resolved one way or the other within a very short time.
You said something about there are a vast number of judges who are ready to, hear the case, hear cases quickly, and if not quickly, at least on its merits. When these things we've been talking about the Supreme Court, because that is, after all, the last appeal for a citizen. When these things happen in the Supreme Court, which we discussed, what is the message that goes on to the lower courts?
Well, if the feeling is that there is nobody looking over your shoulder, and that delay is a delay in human rights issues like incarceration, hearing and deciding bail applications, hearing and deciding remand applications, and so on. If the feeling of judges down the line is that it doesn't matter, it doesn't matter if I hear something after a month or 2 months or 3 months, then that's a very dangerous thing because for the citizen, especially, keep in mind that even today, when we speak of, people like Tista Setalvad or even Omar Khalid or, Mohammed Zubair or others, we are talking about people who at least have access. They have built up a huge fund of goodwill, and they have people looking out for them, and they have lawyers looking out for them, etc. But the vast majority of people who are without access to bail, etc., are very poor people. And those people, that if the message goes out that you can dilly-dally and sit on bail applications, or you can deny people, you can allow charge sheets to be filed long after the outer limit for filing the same. You don't even give the mandatory, what is called statutory bail, where charge sheets are not filed within the outer limit, and so on. Then what happens to all those poor people? Because they don't have access. They don't have people looking out for them. They don't have legal networks, etc., etc. So that message is very dangerous. It's dangerous for the poorest of the poor.
So what you're saying is, if we were to do a sum total of what you have said and what the perception is now, that a citizen may be caught in a crime or even other cases, who's wrongly arrested, who's wrongly charged, and is picked up, now should lose hope in the judiciary? Is that correct?
No. I'm not saying that. I'm saying that the Supreme Court needs to step up to the plate and send out a strong message, because the silence of the Supreme Court or the acquiescence of the Supreme Court in delay, if the Supreme Court itself doesn't send out that strong message that every single bail application has to be accorded the same sort of priority that is given to the rich and famous, the high and mighty, etc., then the disservice which is done to lakhs and lakhs of poor or disadvantaged people who are languishing behind bars. Just look at, for instance, the Unlawful Activities Prevention Act. I wrote not too long ago on the, I think it was perhaps in The Wire, that you have people who have been behind bars for 14 years, 15 years, and they are acquitted. They're acquitted because there's an absolute lack of evidence against them. Entire congregations of people, like there was a conference held in Gujarat, which was a language conference, and the entire lot of them were picked up in 2003 or 2004, and they're acquitted. The whole bunch, 250 people or something who've come from all over India to attend a conference, get picked up, and they get acquitted in 2017 or 18 for complete want of evidence. There's nothing. There's zero against them. And they have 14 years, 15 years of their life. 2-3 years of that, they were behind bars. Then they belatedly got bails. And then they've spent 14, 15 years of their life going every week, having to go from wherever they were, because bail conditions are that you might be living in Uttar Pradesh or Bihar or Tamil Nadu, but you have to report once a week to some police station or once a month to some police station in Gujarat where you were arrested and where you are facing the trial. These are the kinds of things where the Supreme Court must come down very strongly and send out a message that this is intolerable. Why should these bail conditions be put for a person to report every month to somewhere which is 1,000 miles away from his or her residence? Why can't they be allowed to report to a police station in their, in the village that they, or the small town where they live, in whichever part of the country? There are many, many such issues. But yes, the last few years have seen a multiplication of this. What was happening earlier was minuscule compared to what there is today. The level of, for instance, under the Prevention of Money Laundering Act, it's very well documented that you have a situation where, whereas there were a few hundred cases prior to 2014, today there are thousands of raids. 5,000 raids, 6,000 raids have taken place in the last 2 or 3 years. And over 1 lakh crore rupees worth of properties are seized and attached and sequestered. And there is a 1.8% conviction rate. So all those properties which are seized and sequestered, ultimately, when people's lives are destroyed, when people's businesses are destroyed, will be returned to them. Everybody knows that. Everybody knows that. But the system is working, is encouraging state governments to lash out at anybody they see as a dissenter or as a person who, doesn't share their ideology or just because they want to teach somebody a lesson. So these are issues which need to be grappled with. And unless a message goes out from the top court, it is impossible that we will really come to terms with these things.
You'll recall that in the late 70s, early 80s, especially post-emergency, as you pointed out, there were Supreme Court judges who even took a postcard or a letter about an issue and converted it into a petition.
Yes.
Justice Krishna Iyer had done that, I think.
Justice Bhagwati did it. Especially in the early 80s, from 78 onwards, and all your Bandhuwa Mukti Morcha, the quarry workers outside Delhi, the Asiad workers who were bonded labor, Swami Agnivesh's cases, etc. Many of them originated as letter petitions, where they call them letter petitions. The Bhagalpur blindings case was taken up on the basis of a news report in Indian Express. And there have been several. Even today, it's not that the Supreme Court doesn't take up issues. They do take up issues. But the problem really has been that there's a level of selectivity, number one, and that the general state assault on civil liberties and on human rights has grown so much that the courts need to, redouble their efforts to show a pushback and to show the governments that you cannot misuse laws in this way.
Is one of the problems also the overload on cases, especially now, because there are, as you said, a multiplicity of PMLA and so many other things, and the courts are hopelessly overloaded? Is that a problem which is holding back?
I don't think that the overloading of the courts can be used to justify not coming to grips with the most egregious cases. If you have a situation where now the Supreme Court of India, for instance, has, let's say, a backlog of 69,000 cases. Many of those, there can be a prioritization done, etc. It's not as though all those 5,000 raid cases under PMLA have come to the Supreme Court. Maybe 2 or 3 or 4 come to the Supreme Court. The point is that the high courts as well as the Supreme Court, which do get these cases before them, must prioritize them, decide them, and send out a strong message wherever they find that these laws are being misused. They must send out that strong message so that the level of misuse gets curbed. That is the only way of doing it. Now, if you have a 1.8% conviction rate in a law as draconian as the PMLA, that is the proof of the pudding. That shows that there's a gross misuse. You are incarcerating people. You are making it impossible for them to get bail. And what do you get at the end of it? Charge sheets are not filed. And when charge sheets are filed, you get a 1.8% or even less, lower conviction rate than that.
So, again, to come back, many of these cases, PMLA, ED raids, then the citizen goes to the courts, UAPA, can be used at any time, anywhere. You pointed out that state governments feel emboldened and they can be used, misused anywhere. PSA in Kashmir. So this is really a very menacing situation.
It is a menacing situation, but basically, I'm an optimist. I always see the glass as half full. I do believe and I do feel that there has to be a pushback, and the pushback has to be aided and assisted by the courts. No government and no government is invincible, or no government can say that we will ride roughshod over the constitution and the laws. You have let's say, for instance, this use of bulldozers, which is openly proclaimed and used as a crime fighting, with ostensibly as a crime fighting mechanism. You have, senior functionaries, chief ministers, etc., of state saying that rapists and smugglers and blah, blah, blah will be their houses will be demolished and so on. Now, there's no law on earth which says that you can use demolition as a crime fighting mechanism, right? Forget about who's right and who's wrong. But you just cannot use it. Even the most heinous crime which is committed by a criminal, you can't destroy that person's house and render his wife and children and grandparents and grandchildren homeless because you want to teach that so-called criminal a lesson. Even more so when he or she is not even a criminal yet because they are only accused person, right? But this is openly being said and done with zero pushback from the courts. Almost zero pushback from the courts, right? Now, there is no justification. Whatever you may say that a structure is an illegal structure, but they are standing up there. Police commissioners, director generals of police are standing up there and saying, he committed a crime, we are demolishing his house. Right? It was done with that Vikas Dubey, it was done with so-and-so, etc. Now, a Vikas Dubey in a village, it could not have been an unauthorized structure because there's no municipal laws over there, which makes his home unauthorized. But they went with their bulldozers and they demolished his house. They demolished every bit of it, the outhouses, the house, everything, and just made it into rubble. As it happened in that case, it was actually, according to them, there were arms and ammunition there, which means that it was evidence. So they destroyed the evidence. If he was a criminal, then that was evidence of a crime. But they flattened it all. So there can't be a justification of something like this, right? So if the courts don't open their eyes to that and say that we will not allow this to happen, not on our watch, then the governments believe that they can get away with it with impunity. And then another state and another state and another state will do it. It doesn't matter which government is there. It doesn't matter whether it's a government which is aligned with the right or the left or the center. Everybody will do it. Governments, by their very nature, will use power, any power that they perceive to be available to them. And that the check and balance on that power it has to come from the courts.
So you are an optimist. We are seeing a Chief Justice who has quickly got into the act, has listed very, very important cases. Perhaps he's also saying that whether 3 months or 3 years, I think this is important. Do you think this will slow down or end sometime?
I'm hoping, we have Justice Lalit came from the bar. He was a lawyer with an extraordinarily large and busy practice. He was an outstanding counsel in the Supreme Court, and he was elevated. Has spent a long tenure in the Supreme Court. He may be Chief Justice only for 3 months, or slightly less than 3 months, but he's had a long tenure as a judge. So he knows the system. He's known the system as an advocate on record. He's known the system as a top rung senior counsel of the Supreme Court, senior advocate of the Supreme Court, and he's seen the system as a judge. So I think we have to give him a fair chance because he is, showing his intent. And once things are, start moving in a particular direction, I'm very hopeful that the next Chief Justice, who has 2.5 years, the following Chief Justice after him, who also has a fair tenure, will all continue to work on these lines and will try to see that the reputation of the Supreme Court, the great standing which it has enjoyed as the most powerful court in the world is restored, and it comes back to that. This is the thing. We have a great deal to be proud of. We just have to put it back on the rails. We may have got derailed. We may have fallen off the rails a bit, but there's no reason why, with an intent and a will, we can't have everything back on the rails and go back to the position where the Supreme Court is again seen as the most powerful court in the world.
Chander, I may say that at least at the senior lawyers level, there have been many lawyers who have been saying these things. You are a columnist, you are a lawyer, you've been a journalist, and this discussion gives me some, if I want to extrapolate it, for example, it gives me an indication that there is a lot of such thinking going on, and perhaps these things will change for the sake of our democracy. I mean, this is not a discussion on the media, but the media to me sometimes as a practitioner looks as if it's beyond hope now. So, shall we end by saying, conclude by saying that you see some light at the end of the tunnel, to use a cliche?
I do. I genuinely do. I think that, the leadership at the top, at least as far as our courts are concerned, because we have this system of the master of the rolls, the master of the roster, and the Chief Justice of India as master of the roster and a Chief Justice of a High Court too, has a great capacity and a great ability and to mold the court in a direction. The Chief Justice doesn't decide matters, because the matters are going to get decided by 10 or 15 different benches of the Supreme Court, and every bench is a Supreme Court in itself. But the Chief Justice, by his power of assignment, his power to pull out matters, list them, and assign them to different benches, which may have a domain expertise in that area, a bench which may have, a great deal of past knowledge or experience in a particular area, etc. That ability of the Chief Justice to assign matters and to list matters can change the direction of a court. And we have seen it in the past, and I'm really hopeful that we will see it in the future too. And I did at one point say something about that Justice Uday Lalit is a judge who's showing that he can walk the talk. I just want to amplify that, and maybe you could fit this in there. When I said that Justice Lalit is not only talking the talk, but he can walk the talk, it is there's a slightly veiled criticism built in there about the previous Chief Justices, the immediate previous Chief Justices. We have had Chief Justices, including the immediate Chief Justice who preceded Justice Lalit, who on public platforms spoke, eloquently about human rights, about, democratic rights, about the right to speak up, the right to, and freedoms and so on and so forth. There were great speeches, in universities and at various different public platforms, but they were not walking the talk because they were not translating those speeches, bringing those speeches back home in the Supreme Court. The speeches were not translating into judgments. They were not translating into bringing matters out of the dungeons where they are languishing and getting them, throwing the light of day on them and getting them heard and decided. Where Justice Lalit is making a difference in such a short while is that he's walking the talk. He's not just speaking at public platforms. He is speaking by the power of his pen of assignment, of listing. And that is where I think he can make a great difference.
So, on that note, this is a very fair assessment and a bit of good news for the average citizen. As you said, there are thousands, maybe tens of thousands and more people languishing in courts on, there is no day that passes without us reading somebody acquitted about robbery or bribery for 30 rupees 25 years ago or 20 years ago. And it gives, so your assessment gives some hope, if not actual direction, where we can see and go back to an earlier time, which, as you said, we have much to be proud of. And we hope that the judiciary will once again become the sentinel or the beacon of hope for the average Indian. So on that note, I want to thank you, Chander.
Thank you, Sidharth.
Yeah, that was Chander Uday Singh, senior advocate in the Supreme Court, been practicing there for many, many years and giving his analysis of where the Supreme Court, but also the other courts at the moment, where the perception, as I said in the beginning, has grown that they lean more towards the establishment, and that includes the business establishment rather than the rights of the citizen. We'll be back again next week with another guest. Till then, from me, Sidharth Bhatia, and the IVM team, goodbye. You can check out this podcast and other interesting ones on the Wire website, the IVM Podcast website, app, or wherever else that you get your podcasts. Goodbye from me, Sidharth Bhatia, and the Wire Talks podcast team.